When we think of ancient Rome, we often picture grand temples, triumphant generals, and legions marching across continents. But beneath the marble and military might was a structure even more enduring: the Roman legal system. Law was the invisible architecture of Roman life. It defined relationships, structured government, regulated commerce, punished crime, and preserved the empire's stability for centuries. And long after the legions laid down their swords, Roman law lived on, shaping the legal foundations of Western civilization. The origins of Roman law stretch back to the earliest days of the Republic. In 509 BCE, Rome overthrew its last king and vowed never again to be ruled by one man. Yet in this early republican society, legal rights were not evenly distributed. Rome was divided between two main social classes: the patricians, elite landowning families, and the plebeians, the common people. The patricians held most of the political and legal power, and the plebeians grew increasingly frustrated with their lack of legal protection. Their demands led to one of the most important legal developments in Roman history: the creation of the 12 tables in 451 BCE. These were Rome's first written laws, a radical step forward. Until then, laws were unwritten and interpreted by patrician priests, often in secret. Now, for the first time, the law was made public, carved into 12 bronze tablets and displayed in the forum for all to see. The 12 tables covered a wide range of legal issues: family relationships, property disputes, debt, theft, and even funeral customs. They weren't perfect. Some of the rules seem harsh or strange to modern eyes, but they marked the beginning of Rome's transformation into a society governed by laws, not by arbitrary rulings. Over the next several centuries, Roman law evolved dramatically. As Rome expanded, its laws had to keep pace with a growing and diverse population. The Republic had become an empire, ruling over people who weren't Roman by birth. The challenge was enormous. How do you apply Roman laws to non-Roman citizens while maintaining control? The answer came in the form of legal innovation. Roman jurists, highly educated legal scholars, began interpreting and expanding the law, crafting principles that were more flexible and universal. They developed legal categories such as jus civile, and jus natural. These distinctions allowed Rome to govern a vast and multicultural empire while maintaining a coherent legal identity. Roman courts operated with surprising efficiency for their time. Civil cases were typically heard before a praetor, a kind of magistrate who interpreted the law and assigned judges. Criminal trials could involve public juries, and famous advocates like Cicero became known for their dramatic courtroom speeches. There were rules for presenting evidence, questioning witnesses, and appealing decisions. The process was not always fair by modern standards, but it was systematic and sophisticated. Punishments varied depending on the crime and the class of the accused: fines, exile, forced labor, and in serious cases, execution were all possible outcomes. Yet Roman law wasn't solely focused on punishment. It also protected private rights, contracts, property ownership, family inheritance. Roman citizens, especially those of higher rank, could go to court to defend their rights under well-established principles. This was a legal culture rooted not only in command but in precedent and procedure. One of the most remarkable features of Roman law was the role of jurists. These were not government officials, but private legal scholars who studied the law, wrote commentaries, and advised magistrates. Their writings were so respected that they became part of the legal tradition. Jurists like Gaius Papinian and Ulpian wrote detailed legal opinions that would later serve as the backbone of Roman legal codes. Over time, the growing complexity of Roman law led emperors to take a more active role in streamlining and organizing it. This culminated in one of the greatest legal achievements in world history, the Corpus Juris Civilis, or the Justinian Code. In the 6th century CE, Emperor Justinian, the first of the Eastern Roman Empire, commissioned a massive project to collect, refine, and unify Roman law. The result was a 4-part legal compilation: the Codex, the Digest, the Institutes, and the Novella. The Justinian Code didn't just preserve Roman law, it elevated it. For centuries after the fall of the Western Roman Empire, Europe was fragmented into kingdoms and tribal territories with little legal coherence. But when scholars rediscovered the Justinian Code in the Middle Ages, it reignited a legal renaissance. Universities in Bologna and other cities began teaching Roman law. Kings, popes, and emperors drew upon it to shape their own legal systems. Roman law became the foundation of civil law. The legal tradition followed today by most of Europe, Latin America, and parts of Asia and Africa. Even in countries that follow common law like the United Kingdom and the United States, the influence of Roman legal concepts is evident. Ideas like contracts, torts, legal obligations, and rights of the accused trace their roots back to Roman jurisprudence. The very notion that laws should be written, public, and applied consistently, that no one is above the law, is a Roman legacy. Roman law also introduced some of the earliest forms of legal equality. While Rome was never an egalitarian society, its legal system gradually recognized the rights of all citizens, regardless of class. Freed slaves could own property and make wills. Women, though limited by guardianship laws, could inherit wealth, manage estates, and initiate lawsuits. Legal protections existed for minors, debtors, and foreigners. In this way, Roman law served as both a reflection of social hierarchy and a tool for integrating diverse populations into a unified legal framework. Perhaps one of the most powerful aspects of Roman law was its pragmatism. The Romans were not rigid idealists. They adapted the law to suit the needs of a changing world. Laws were updated, repealed, or reinterpreted as circumstances demanded. This flexibility made the legal system durable. It could survive regime changes, civil wars, even the division of the empire itself. Law was everywhere in Roman life, not just in the courtroom but in the streets, the markets, the temples, and the home. Contracts were sealed with a handshake and a formula. Property was transferred through rituals and witnesses. Marriages, adoptions, and inheritances all had legal frameworks. Even slaves had limited protections under the law, and their manumission followed legal procedures that made them citizens. Rome was a society governed by legal ritual, a society where justice, however imperfect, was institutionalized. And like everything in Rome, law was also a matter of prestige. Emperors prided themselves on being lawmakers. Magistrates displayed their legal judgments on stone monuments. Citizens invoked the law in everyday disputes. Even in the empire's decline, legal reasoning endured as a pillar of Roman identity. While armies retreated and borders crumbled, law remained. In modern times, we often take legal systems for granted, but the Roman example reminds us how powerful a tool law can be, not just to control, but to organize, integrate, and preserve a civilization. The Romans understood that an empire built on conquest alone would fall, but an empire built on laws with rights, rules, and procedures might outlast its armies, and so it did. Roman law lived on not in the temples or the triumphal arches, but in the law books of medieval Europe, the civil codes of modern France and Germany, the textbooks of law students, and the courtrooms of the world. The shadow of Roman justice stretches far beyond the ruins of the Forum. It is written in the codes, contracts, and constitutions that govern us today.